start a new topic, Indian Constitution, and the topic is equality before law. Okay, equality before law, it is coming on Article 14 of Indian Constitution, fundamental right. Fundamental right, Article 14 is the equality before law. Okay, equality before law. Let's start the topic. The state shall not deny to any person equality before law or the equal protection of law within the territory of India. So, state shall not deny any person equality before law or the equal protection of law. All the people are coming under in a same category when it is coming the word equality. Everybody in this citizen, everybody of the country is equal before law. The king, the rule is applied to the king to the same, the servant to the same, and any of the person who are belonging to the country are equality. Everybody are equal. Right to equality before the law has been bestowed on every person, whether that person is a citizen of India or not. If that person is not belonging to our country, if some other country's person also coming to our country, he will also get the same facility, right to equality before law. He will get the right also equality before law. Or our country people also get the equality before law. Article 14 is based on the theory of rule of law. So, A.V. Dicey, who has introduced the rule of law, so it is a right to equality also based on the theory rule of law. Okay, so everybody are equal under law. Nobody is superior to the law. All the persons who are belonging to any category, who is it is in a top position or in a low position, on the in the case of law, everybody are equal. It makes an open commitment to provide equal protection to all persons within the territory of India in the enjoyment of their rights and privileges. So, whatever the rights of everybody in the country, so everybody's rights should be protected under Article 14. It is a declaration against all kind of discrimination. Nobody should be discriminated in any matter. Okay, and favoritism which may ensue from legislative and executive action of the state. Whatever the rule, legislation or executive will make, it is in favor of the country for the protection of the country's people, not any discrimination of the people's right. Now, doctrine of equality, what it explains. The Epics Code held all the persons and things similarly circumstanced shall be treated alike in privileges and liability imposed. Here what it is mentioned, all the peoples and persons similarly circumstanced shall be treated alike. Okay, suppose we have to, when we are making the right to equality, so we have to concentrate how the people are of our country. If the people are below below education, below income, how they will treat under the right to equality, and how the people who are in more rich. That all the equality, when we are providing any rule, we have to concentrate the circumstances of the people, how they are, how their life is belonging. In other words, equal should be treated equally. All the equal people should be treated, and unequal should be treated differently. If the persons are not belonging to that equal people, they are differently living. So, country has to apply properly rule for that, properly law for them. The different peoples, court will provide any different rule for them for the protection of equality. For the purpose of classification, even a single person may be treated as a class himself. So, when right to equality provides our constitution fundamental right, so even a single people should not be discriminated. One single person also get the right to equality. Doctrine of equality cannot be considered as a mandate that every law must be universally applicable for all persons who are not by the nature, attainment, capability or circumstances in the same position. The varying need and other cross-factor people may look for the distinct treatment. So, here what doctrine of equality explains, when you are preparing some law for the people, we have to see how the nature of that people, attainment, capability or circumstances. By looking on that conditions, we have to make the law. Without that, if you will universally make some laws, only rich people will get the facilities, poor people will not get the facilities. poor people be like that, and rich people are be more rich. So we have to see the capabilities, the nature and the circumstances of that poor people, the educationally backward people, by looking all the things, how the income source of the lower people, like poor people. So by looking everything, we have to make the law, then only it will be equality to the all the person. Neither the poor people will be poor and rich people will be rich. However, the classification should be reasonable and not arbitrary one. So the classification should not be arbitrary, it should be reasonable. The right to equality should be reasonable. The classification should be reasonable, with not the arbitrary one. So two tests here written, two tests of classification, right to equality. The classification must be founded on an intelligible differentia. The word, it is very important, intelligible differentia, which distinguishes persons and things that are grouped together from others left out of the group. So here it is, the intelligible differentia means distinguishes persons or things of one group differentiated from the other group. Such some people or circumstances, economic source, education are not improved. So we have to look that group, how we will improve that peoples to the other group. By looking this, we have to make the right to equality, intelligible differentia. We cannot provide any divine law on all the people treated equally. We cannot say like that. So we cannot improve the below people to the upwards. The differentia must have a rational relation to the object sought to be achieved by the concerned act. So it is a differentia must have a rational relation to the object. Suppose country has enacted something that will be beneficial for that group people. So intelligible differentia is by looking to the things, to the people, to the group, how the peoples economically improved, how the people educationally improved. By looking everything, we have to make the rule, to make the law. Then only it will be equality for everybody. Now in one case law is there, Chiranjit Lal Chaudhary versus Union of India, year 1951, Supreme Court 41. In this case, the Governor General of India promulgated an ordinance which purported to make special provision for management and administration of the Solapur Spinning Weaving Co. So, government has made some provision for the management of and administration of the Solapur Spinning Weaving Co. Limited. April 7, 1950, ordinance was replaced by an Act of Parliament known as Solapur Spinning and Weaving Co. Limited Act. So the name is Solapur Spinning and Weaving Co. Limited Act. It was the ordinance was replaced on the April 7, 1950 by the Parliament. Okay, the constitutional validity of the ordinance and the Act was challenged on various grounds. So it was challenged on various grounds. There was everything lost in that company. So it was in challenge. One of the ground of challenge was that enactment denied the company and its various shareholders equality before law and equal protection of law and therefore violated of article. So they demanded that our right to equality is violated because we are not, it is a challenge. The enactment is denied by the company. Various shareholders are not equally treated. They are prohibition of the equality and the protection. So therefore violation of Article 14. But court told it was held that Article 14 was not violated even though the legislature had proceeded against only one company and its shareholder. So court ordered that it is a not violation of Article 14. Even a one company also legislature had proceeded against only one company and its shareholder. If it is providing any rule for the one company for the employment or the benefit of that company, because that company is dependent to the all peoples, so it is not the violation of Article 14. Thus the law made by constitutional even though it relates to a single individual. If a single individual also violating the rights of equality, then also court will provide the some facility for that single individual, how he will get the equality before the law. So this is the case, and another case is it is State of West Bengal versus Anwar Ali 1952 SCR 913, and third one is Kathi Running Rawat versus State of Saurashtra AIR 1952 Supreme Court 123. And fourth one is Maneka Gandhi versus Union of India. It is also a right to equality case, AR 1978, Supreme Court 248. Court held that Article 14 requires the observance of the principle of natural justice, including the requirement of reasoned decision. So here it is mentioned here that Article 14 also look the natural justice. If it is based on the equality, should be also based on the natural justice. Then only people will get the reasonable decision and the reasonable right. It should not be arbitrary one. And one more is tax law with reference to equality. Article 14 covers the tax law too. So it provides also tax law. Tax, when we are enacting the tax law, Article 14 also apply to that. Article 265 provides in simple words that states shall levy or collect tax except by the authority of law. So without the authority of law, state cannot collect tax or levy tax on the people. State has been given abundant power for purposes of taxation. State can collect the tax, but by the authority of law. It is a wide range and flexibility. It is a wide range and flexibility. State may use discretion in taxing some person or object and leaving the rest. So it is a discretion. This rule is a discretion. The tax department, they will decide. They will consider that this object, this person will give the tax, or that person no need to give the tax. According to their salary, their employment, the tax will be collected. According to their income source, the tax will be collected. So the case law are 1 B.M. Syed Muhammad and Co. versus State of Andhra, AR 1954, Supreme Court, and another is Kerala Hotel and Restaurant Association versus State of Kerala, AR 1990, Supreme Court 913. So this right to equality is over. Thanks for watching.